Okay, here we go. I've got Ron DeSantis's all the defendants motion to disqualify Chief Judge Mark Walker. This is in the federal court, so I'm just going to go through this here. So defendants move to disqualify Chief Judge Mark Walker under 28 USC section 455A because the court's impartiality in this matter might reasonably be questioned. This case involves claims that defendants retaliated against Walt Disney Parks and Resorts based on Disney's viewpoints. Yet, two previous times, in two unrelated cases, the court sua sponte, which means on its own without prompting by another party, offered Disney as an example of state retaliation. Those remarks, each derived from extrajudicial sources, the news, were on the record in open court and could reasonably imply that the court has prejudged the retaliation question here. Because that question is now before this court, and because that question involves highly publicized matters of great interest to Florida citizens, the court should disqualify itself to prevent even the appearance of impropriety. And I actually like how the attorneys approach this, because they're not coming at the judge and saying, "You're biased and we know it." They're saying, "You made these remarks. Even if it just appears that you might have a bias, and we're not saying that you do, we're just saying that it appears to be such, then the appropriate thing to do under the statute, which will be addressed, is to let another judge take over." So now they're going to get into the two instances they're talking about where the judge commented about Disney. First case is Link versus Corcoran. And the plaintiffs said that state education officials would punish them, the plaintiffs, for the results of their intellectual freedom and viewpoint diversity surveys. This is an education case. The plaintiffs argued that government reprisal is not a speculative risk because Governor DeSantis and Commissioner Corcoran have practically promised retaliation against plaintiffs' speech. And so then the court's going to get into, well, I don't know if this is speculative or there's specific threats, because in order for me to grant an injunction preventing them from doing something, we have to it has to be specific. It can't just be speculative. It has to be for sure. So the court says, I don't understand how, it seems to me how you can say that threat, the chill or the chilling of your speech, is reasonable when you've got to assume so many things. They go on, and the judge talks about, in the UF professor case, University of Florida, the chill, they knew who they were targeting, and they could target individuals, and so there was, and had announced their intent to do so, so they were attacking specific people in specific ways. So the judge is asking, what's in your record here, plaintiffs? For example, is there anything in the record that says we're now going to take away Disney's special status because they're woke? Something of that nature. So there's his comment about Disney. He's saying, give me some specific examples of the government going after you. What are they doing? He used Disney as an example of retaliatory act. So again, what's in the record that shows these very people have taken punitive measures against those they've described as woke in other contexts? Give me something here. So the court is saying, or not the court, sorry, the defendant's attorneys are saying, you've already concluded here that Disney was already a victim of government retaliation, because you're saying it could be an example of retaliation. In other words, this is how you've obviously prejudged this case that's now before you. So the second case, Falls versus DeSantis. Now this is, and just the timing wise, I should mention that last case, this was just before, this case was going on just as they were announcing that they were going to do something about Disney. So nothing had actually been done yet. This next case comes somewhat similar. Well, let's see, am I mixing that up? I think it was just talk of that. Maybe I'm mixing that up, but this other one on the same day that SB 4C became law. So the SB 4C again was the law that said that they would be dissolving the Reedy Creek district. That was followed by HB 9B, which said they weren't dissolving it, they were reconstituting it. So that's where we are in the timeline here. Falls versus DeSantis. There was a preliminary injunction on the argument that the state level defendants would take enforcement action against the plaintiff's schools if the plaintiffs expressed opinions that violated the Individual Freedom Act, thus chilling their speech. So if we say something you don't like, you can take recourse against us. The court summarized the plaintiff's theory that their speech was chilled because the defendants can, or so the state can, under existing regulations, cut funding, and if your school is going to lose funding, then it would certainly create a chilling effect on a professor who doesn't want to be the source or cause of his school losing revenue. So that's the specific threat that the judge was looking for in the other case. I mean, similar to. So then they have a discussion with the defense. So this is a discussion with the state's attorneys where, again, they're talking about threats and the fact that the government can retaliate. And so the court says, and then Disney is going to lose its status because, arguably, because they made a statement that ran afoul of state policy of the controlling party. At what point do you stack so many examples where punitive actions are taken if you don't do what you're told that suddenly it no longer becomes conjectural and you pass that threshold so you can establish standing? It's no longer fanciful or conjecture. So the DeSantis argument is here that the court cited Disney losing its status as among a pattern of punitive actions, suggesting that other future retaliation might not be speculative. So those are the two examples of cases where they're saying that Judge Walker has already found that the state's conduct against Disney was retaliatory and punitive. So he's prejudged the case. So based on the fact that he's prejudged the lawsuit, they're not going to get a fair shake, and so the judge should recuse himself and allow a different judge to take over. So let's go over the legal standard here. The statute that they quoted, 28 U.S.C. section 455A, says a federal judge shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. And in the law, there's a big difference between shall and may. Shall is mandatory, may is discretionary. So what they're going to say is that this standard is mandatory disqualification. And so the only thing we're wondering whether we need to look at is, can the impartiality of the judge be reasonably questioned? So the standard is whether an objective, fully informed lay observer would entertain significant doubt about the judge's impartiality. So this is kind of in the law, we talk about a reasonable person standard. It's just like, what do you think a reasonable person would do? And sometimes that's totally fake. For example, I used to represent a lot of lower income people in cases, and the court would say, if you get served a lawsuit, a reasonable person would go hire an attorney and figure it out. It's like, well, these people don't have money to hire an attorney. Obviously, they're not going to do that. And it's very reasonable that you don't know what to do with these things. So you set it aside and hope that nothing bad happens. But anyway, then you go into court and ask the court to give them a chance. And they say, no, a reasonable person wouldn't have acted the way they did. It's like, that's what everyone does. Anyway, so the reasonable person is a little bit of a myth. It's like, how do we want people to act? And so anyway, when we say a fully informed lay observer, there's a lot of, that's very squishy. The touchstone for recusal under section 455A is not the reality of bias or prejudice, but its appearance. So the very purpose of 455A is to promote confidence in the judiciary by avoiding even the appearance of impropriety whenever possible. Supreme Court. That's all I'm going to say. So anyway, their argument again has already been summarized. It's that, hey, judge, you've already made a decision here. And they cite a case that I think is important as an example called Franklin. In Franklin, a trial judge had referred to Franklin, a defendant, who was alleged of committing additional crimes while released on bail, as an example for why a different defendant should not be released on bail. So the point in that case was that this Franklin defendant, it seemed like the judge had already determined that he'd committed an additional crime after being released on bail, even though he was only allegedly, he had alleged to have done that crime. So the judge it was mandatory for him to recuse himself based on the fact that it looked like he had already determined that this defendant was guilty of a subsequent crime. So in context, despite the judge's use of the magic words alleged, because Mark Walker said allegedly in the Disney quote, let me just go back to it. Oh, he used arguably. Disney is going to lose its status because, arguably, because they made a statement that ran afoul of DeSantis. So they're saying, even though you said arguably, it doesn't matter. Alleged. The inference is irresistible that the judge was pointing to Franklin as a latest such incorrigible criminal, even though Franklin's trial had not yet taken place. This is powerful circumstantial evidence that the judge had prejudged Franklin's case, and that was the appeal court. So they're saying this is the same type of thing. It's obvious that Walker has already determined in his mind that Disney was the victim of wrongful retaliatory conduct by DeSantis and his government. And they say a good judge should engage in self-reflection in determining whether to remain on a case. The court's prior statements at least raise a substantial question about whether the court will resolve this matter fairly. And I think it's a really good move by DeSantis' attorneys because, number one, it might actually work. I mean, I think it's a really good argument if I were the judge. And I've had judges recuse themselves before. Like, for example, I was in a case and a judge, I just went to church with him and he disclosed that we went to church together. And the other attorney, the other attorney said, "Hey, I don't have a problem with that. It's fine. I'm sure you'll be fair." But the judge decided that he was going to recuse himself anyway, just because he didn't want the case to go bad, or the case, he didn't want to rule in my favor, and then the other attorney would end up deciding, hey, it is just because they're church buddies. So I don't think the standard is that high for judges to say, yeah, maybe I should recuse myself. And like they quoted, a good judge would say, look at it objectively and say, yeah, maybe I did prejudge here and I should let another judge take over. So I wouldn't be surprised if that happened. At the same time, if the judge decides, no, I'm gonna stay in the case, and then he rules against DeSantis, it's just a way that DeSantis could go, hey, look, we knew this was going to be the outcome from the very beginning. This was a stacked court, biased judge. He displayed his bias already. No wonder he ruled against us. And so it's just a way for, if Judge Walker does end up ruling in favor of Disney, that you're going to have some public outcry and say this was all rigged from the beginning. It wasn't a fair trial. And so in some ways, if I were Disney, I might say, yeah, I guess maybe I would be fine with another judge stepping in. But at the same time, maybe you don't want that to happen because you think Walker's going to rule in your favor. Anyway, so it just raises a really good issue. Very curious to see how Disney responds. Maybe even the judge will make a decision without having a response. So I'm going to be monitoring the docket, and we'll see what happens here. But regardless, I do think you got to question, why are there so many cases where people are going into the court asking about DeSantis's government attacking him for exercising their speech? I mean, this is at least two where he talked about Disney, and then we're on our third, which is the Disney case. So how many of these are going on? That's a question I do have. Okay, one more thing I just wanted to add on this judge issue. So let's say you want to have a judge that's of your same political ideology. So if I'm going to the Northern District's Court of Florida, there's 8 judges, 1, 2, 3, 4, 5, 6, 7, 8 district judges. And if I pull them all up, the first one is Walker. He was nominated by Obama. So we'll just go through them here. There's a Ronald Reagan nomination, Clinton, Obama, Bush, Trump, oh, Gerald Ford, and Bush. So if I'm DeSantis, I'm thinking the odds of me getting an attorney or a judge that might be more conservative minded is pretty good if you can get Walker off the case. So that might be something else they're doing. A lot of things going into play. Just thought that was an interesting point. Hey, if you thought this video was at all interesting, or if you want to see what happens next, please like and subscribe. It helped me out a lot. Thanks.